Question 1. A California Notary Public is asked to notarize a document that will be filed in another country. The document is written in a foreign language that the notary does not understand. The notary should A. Refuse to notarize the document. B. Notarize the signature after having the signer translate the document aloud. C. Notarize the signature as long as the notarial certificate is in English. D. Refer the signer to a notary who is fluent in the foreign language. Answer: C. Notarize the signature as long as the notarial certificate is in English. A notary public can notarize a signature on a document written in a foreign language because the notary's role is to verify the identity of the signer, not to understand or validate the document's content. The critical requirement is that the notary must be able to read and understand the notarial certificate wording, which must be in English. For example, if a document is in Spanish but has an attached English acknowledgement certificate, the notarization can proceed after the notary properly identifies the signer. Always remember that you are notarizing the signature, not the document's contents, so your focus is on the signer's identity and the English language certificate. Question 2. If a notary's journal is lost, stolen, or surrendered to a peace officer, the notary must notify the Secretary of State by certified or registered mail within what time frame? A. Immediately. B. Within 10 days. C. Within 30 days. D. Upon renewal of the commission. Answer: A. Immediately. In the event a notary's journal is lost, stolen, or otherwise compromised, the notary is required to provide immediate written notice to the Secretary of State. This immediate notification is crucial for preventing fraudulent use of the notary's information and protecting the public. For instance, if a notary realizes their journal is missing from their locked desk, they must send a letter by certified or registered mail to the Secretary of State that same day if possible. Think of it as an emergency situation. The more time that passes, the greater the potential for misuse, so the law requires you to act without delay. Question 3. When a member of the public requests a copy of a line item from a notary's journal, the notary may charge a maximum fee of A. $15 per line item. B. $1 per page. C. 30 cents per line item. D. No charge is permitted. Answer: C. 30 cents per line item. California law strictly regulates the fees a notary can charge, and for providing a copy of a line item from the journal, the maximum fee is 30 cents. This fee is intended to compensate the notary for the minimal time and materials involved in fulfilling the request while keeping it accessible to the public. It's important to know that this is separate from the fee for performing a notarial act itself, which has a higher limit. A good way to remember this is to associate the small, specific nature of a journal line with a very small, specific fee. Question 4. A subscribing witness may be used to prove the execution of a document when the principal signer cannot appear before the notary. The subscribing witness must be identified by A. The notary's personal knowledge. B. One credible witness known to the notary and the subscribing witness. C. Two credible witnesses who do not know the subscribing witness. D. The oath or affirmation of one credible witness who is personally known to the notary. Answer: D. The oath or affirmation of one credible witness who is personally known to the notary. When identifying a subscribing witness for a proof of execution, a notary must rely on the sworn testimony of a single credible witness who the notary personally knows. This chain of trust ensures the identity of the subscribing witness is properly vetted, as the credible witness is essentially vouching for them under oath. For example, if your friend, the credible witness, brings in their colleague, the subscribing witness, you would administer an oath to your friend to confirm the colleague's identity. Remember this two-person rule for identifying a subscribing witness: one credible witness you know personally is required. Question 5. When a signer uses a signature by mark, how many witnesses are required? A. One witness, who must be the notary. B. 2 witnesses, one of whom may be the notary. C. 2 witnesses, neither of whom may be the notary. D. 1 witness, who must sign the signer's full legal name. Answer: C. 2 witnesses, neither of whom may be the notary. The procedure for a signature by mark requires the mark to be witnessed by 2 individuals, and the notary performing the notarization cannot serve as one of those witnesses. The notary's role is to notarize the act, which includes overseeing the procedure, while the witness's role is to observe the signer making their mark. For example, if an elderly person can only make an X, 2 other people present must watch them do it and then sign their own names as witnesses on the document. The key is to maintain impartiality. The notary is the official overseer, not a participant witness in the signing. Question 6. A California notary public must hold a surety bond in the amount of A. $10,000. B. $15,000. C. $25,000. D. $100,000. Answer: B. $15,000. Every California notary is required by law to obtain and maintain a $15,000 surety bond for the duration of their 4-year commission term. This bond is not insurance for the notary, it is a financial guarantee to protect the public from financial harm resulting from the notary's misconduct or negligence. For instance, if a notary's error on a real estate document causes a financial loss to a client, the client could file a claim against the bond to recover their damages up to $15,000. Think of the bond as a promise to the state and public that a fund exists to cover damages if you make a costly mistake. Question 7. A notary is asked to notarize a document that has blank spaces. The correct action for the notary to take is: A. Fill in the blanks with "not applicable" or "not applicable" before notarizing. B. Instruct the signer to fill in the blanks before proceeding with the notarization. C. Notarize the document as is, but make a note in the journal about the blanks. D. Refuse to notarize until the blanks are filled in by the document creator. Answer: B. Instruct the signer to fill in the blanks before proceeding with the notarization. A notary must refuse to notarize a document that contains blank spaces or is otherwise incomplete, as this creates a significant risk for fraud. The correct procedure is to have the signer fill in the empty spaces or line them through before the notarization is completed. For example, if a car title has the "sales price" field left blank, the signer must write in the amount or draw a line through the space before the notary can proceed. Always remember the rule, no blanks allowed, as your seal on an incomplete document could enable someone to fraudulently add information later. Question 8. For which of the following documents is a notary required to obtain the signer's thumbprint in the journal? A. A deed of trust. B. A vehicle title transfer. C. A personal letter. D. A living will. Answer: A. A deed of trust. California law mandates that a notary must obtain a thumbprint in their journal for any document affecting real property, as well as for a power of attorney. A deed of trust is a prime example of a document that directly affects real property, as it secures a loan with the property as collateral. This requirement serves as a powerful deterrent to real estate fraud. A simple way to remember this is to think that if the document involves land or a house, a thumbprint is almost certainly required. Question 9. What is the primary purpose of an acknowledgement? A. To have the signer swear that the contents of the document are true. B. To certify that the signer personally appeared before the notary and acknowledged signing the document. C. To create a certified copy of the original document. D. To verify the legal validity of the document being signed. Answer: B. To certify that the signer personally appeared before the notary and acknowledged signing the document. The fundamental purpose of an acknowledgement is for the notary to certify that the signer appeared, was positively identified, and acknowledged that they signed the document. Unlike a jurat, the signer is not swearing to the truthfulness of the document's contents, they are simply confirming that the signature is theirs. For instance, when a person signs a grant deed, the acknowledgement ceremony confirms their identity and that they admit to signing it willingly. A helpful tip is to focus on the word acknowledge, the signer is acknowledging their own signature. Question 10. A notary public may not notarize a signature for which of the following individuals? A. A close friend. B. Their own spouse on a document creating community property. C. A distant cousin on a rental agreement. D. Their employer on a business contract. Answer: B. Their own spouse on a document creating community property. A notary is disqualified from performing a notarial act if they have a direct financial or beneficial interest in the transaction, and notarizing for a spouse on a document affecting community property presents such a conflict. Since community property laws mean the notary would gain a financial interest through their spouse's transaction, they are not impartial. For example, notarizing your spouse's signature on a deed that adds a property to your shared assets would be a prohibited act. The rule of thumb is simple: if the transaction could put money in your pocket, directly or indirectly, you cannot be the notary. Question 11. If a notary changes their business or residence address, they must notify the Secretary of State. A. Within 10 days of the move. B. Within 30 days of the move. C. Immediately by telephone. D. Upon renewal of their commission. Answer: B. Within 30 days of the move. California law requires a notary to provide written notice to the Secretary of State within 30 days of any change to their business or residential address. This ensures the Secretary of State has current contact information and can properly locate the notary if needed. Missing this deadline can result in a fine, so it's a critical administrative task. A good way to remember this is to link it with other common 30-day notifications you might make after moving, like for the DMV or post office. Question 12. A jurat is a notarial act where the notary certifies that the signer A. Acknowledged their signature on the document. B. Appeared before the notary and provided satisfactory evidence of identity. C. Signed the document in the notary's presence and swore to the truthfulness of its contents. D. Is competent and understands the document they are signing. Answer: C. Signed the document in the notary's presence and swore to the truthfulness of its contents. The key components of a jurat are that the signer must personally appear, sign the document in front of the notary, and be administered an oath or affirmation by the notary, swearing that the statements in the document are true. This is a more involved act than an acknowledgement because it deals with the veracity of the document's content. For example, in an affidavit, the signer must raise their hand and swear to the notary that the facts they've written are accurate. Remember the phrase, "sworn to before me," which is the essence of a jurat. Question 13. A notary's official seal must contain all of the following information except A. The notary's commission expiration date. B. The county where the notary's bond is filed. C. The name of the notary as it appears on the commission. D. The notary's commission number. Answer: B. The county where the notary's bond is filed. A California notary's official seal must include the words "Notary Public," the state seal, the notary's name, the commission expiration date, and the notary's commission number. The county where the notary's oath and bond are filed is required in the journal's venue section for each notarization, but it is not a required element on the seal itself. This allows a notary to perform notarizations anywhere within the state of California, regardless of their principal place of business. To keep it straight, think of the seal as containing your personal notary credentials, not your geographic filing location. Question 14. What is the maximum fee a California notary may charge for administering an oath for a deposition and issuing the certificate? A. $15 per certificate, plus $7 for the oath and $7 for each signature. B. $30 for the complete service. C. $15 for the certificate only. D. $7 for the oath and $7 for the certificate. Answer: A. $15 per certificate, plus $7 for the oath and $7 for each signature. For matters related to depositions, notaries have a different fee structure than for standard notarial acts. The law allows a notary to charge $15 for the certificate on the deposition, an additional $7 for administering the oath to the deponent, and another $7 for each signature on the deposition transcript. This recognizes the additional responsibilities involved in deposition proceedings compared to a simple acknowledgement. Remember to break down the service into its components: certificate, oath, and signature, each having its own allowable fee. Question 15. A notary public who knowingly and willfully makes a false statement in a notarial certificate is guilty of: A. A misdemeanor. B. An infraction. C. Forgery. D. A felony. Answer: C. Forgery. A notary who intentionally falsifies information on a notarial certificate, such as stating a person appeared when they did not, is committing a serious crime equivalent to forgery. This act undermines the entire purpose of notarization and is prosecuted as a felony due to the high level of public trust placed in notaries. For example, falsely certifying an acknowledgement on a property deed for an absent signer would be considered forgery. This is one of the most severe offenses a notary can commit, so always remember that the information on your certificate must be completely truthful. Question 16. A credible witness used to identify a signer must: A. Present a valid, unexpired government-issued ID. B. Sign the notary's journal and present an acceptable ID. C. Be personally known to the notary. D. Be a relative of the signer. Answer: C. Be personally known to the notary. The defining characteristic of a credible witness is that the notary must have personal knowledge of the witness's identity. This personal knowledge establishes a foundation of trust, allowing the notary to rely on the witness's sworn statement to identify the main document signer. The witness must also swear or affirm the signer's identity and cannot have a financial interest in the document. For instance, if you don't know the signer but you do know their companion, that companion can serve as a credible witness for the signer, provided they take an oath. Question 17. The venue portion of a notarial certificate, such as State of California, County of __________________, indicates: A. The county where the signer resides. B. The county where the document will be filed. C. The county where the notary's commission is filed. D. The county where the notarization is taking place. Answer: D. The county where the notarization is taking place. The venue statement establishes the geographic location where the notary and the signer are physically present at the time of the notarization. It is a critical piece of information that confirms the notary acted within their jurisdiction. For example, if you meet a signer at a coffee shop in Los Angeles County to notarize their signature, the venue on the certificate must state County of Los Angeles, regardless of where the signer lives or where your commission is filed. An easy way to remember this is that the venue is where you're at when you notarize. Question 18. A notary is asked to perform a copy certification. In California, a notary can certify a copy of: A. A birth certificate. B. A power of attorney. C. A university diploma. D. A driver's license. Answer: B. A power of attorney. California law strictly limits the types of documents a notary can make a certified copy of, and a power of attorney is one of the few explicitly permitted examples. Notaries are generally prohibited from certifying copies of vital records like birth certificates or public records like driver's licenses, as certified copies of those must be obtained from the issuing agency itself. The other key document a notary can certify a copy of is an entry from their own notarial journal. Think of copy certification as a very rare exception. For most documents, you'll need to use a copy certification by document custodian form instead. Question 19. If a notary resigns their commission, is disqualified, or has their commission revoked, they must deliver all notarial records and papers to A. The Secretary of State within 30 days. B. The county clerk where their current oath is on file within 30 days. C. Any licensed and bonded notary public. D. The local police department. Answer: B. The county clerk where their current oath is on file within 30 days. Upon termination of a notarial commission for any reason, the law requires the former notary to surrender their journals and official papers to the county clerk of the county where their oath of office is filed. This must be done within a 30-day timeframe to ensure the records are properly preserved and remain accessible for public record requests. For instance, if your commission expires and you do not renew it, you must take your journals to the county clerk's office, not the Secretary of State. The key is that records are kept at the local county level, where your oath was originally filed. Question 20. Which of the following forms of identification is acceptable for a notarization in California? A. A credit card with a photograph. B. A student ID card from a private university. C. A foreign passport, provided it is stamped by the U.S. Citizenship and Immigration Services. D. An employee ID badge from a private company. Answer: C. A foreign passport, provided it is stamped by the U.S. Citizenship and Immigration Services. California law lists specific forms of identification that are acceptable for notarization, and a foreign passport is on that list. However, it must be valid and either current or issued within the last 5 years. An older version of the law required a stamp from the USCIS, formerly INS, but recent updates have removed this requirement for passports. They just need to be valid. Despite the changing nuance, it remains the only acceptable ID among the choices, as credit cards and private IDs are not government-issued and do not meet the statutory requirements. Question 21. A California notary who is not a licensed attorney is advertising their services. The advertisement must include a statement that the notary A. Is not an attorney and cannot give legal advice. B. Is bonded and insured. C. Charges fees set by the Secretary of State. D. Has passed a background check. Answer: A. Is not an attorney and cannot give legal advice. To prevent the unauthorized practice of law, any notary public who is not an attorney and advertises their services must include a clear disclaimer stating they are not a lawyer and cannot give legal advice about immigration or any other legal matter. This is particularly important in communities where the term notario publico can be misinterpreted to mean someone with legal authority similar to an attorney. For example, a flyer for notary services must explicitly say, "I am not an attorney and, therefore, cannot give legal advice." This rule is about protecting consumers from receiving unqualified legal counsel. Question 22. What is the main purpose of a notary's journal? A. To serve as a personal diary of notarial acts for the notary's reference only. B. To act as a public record and a protective tool against accusations of negligence. C. To provide the Secretary of State with a monthly report of all notarizations. D. To function as a receipt book for fees collected. Answer: B. To act as a public record and a protective tool against accusations of negligence. The notary journal serves a dual purpose. It is a chronological public record of all official acts and a critical piece of evidence that protects the notary from liability. A properly maintained journal demonstrates that the notary followed all required procedures, such as identifying the signer and taking a thumbprint when necessary. If a notarization is ever challenged in court, a complete and accurate journal entry is the notary's best defense. Think of your journal as your professional shield. It proves you did your job correctly. Question 23. A notary may not certify a copy of A. Power of attorney. B. Journal line item requested by the Secretary of State. C. Birth certificate. D. Journal line item requested by a member of the public. Answer: C. A birth certificate. Notaries are explicitly prohibited from certifying copies of vital records, such as birth, death, or marriage certificates, because these are recordable documents for which certified copies are only available from the official issuing agency, e.g., the county recorder or Department of Health. Certifying a copy of a vital record is a serious offense. The other options are permissible. Notaries can certify copies of powers of attorney and entries from their own notarial journals. The easy rule to remember is if the document is a vital record, only the official custodian can certify a copy. Question 24. A notary is presented with an identification card that is expired but was issued within the last 5 years. The ID is otherwise valid. The notary should: A. Reject the ID as it is expired. B. Accept the ID as valid proof of identity. C. Accept the ID only if the signer is personally known to the notary. D. Require the signer to provide a second, unexpired form of ID. Answer: B. Accept the ID as valid proof of identity. California law allows a notary to accept an identification document that is expired, provided it was issued within the last 5 years and meets all other requirements, e.g., it is government issued, contains a photograph, signature, and physical description. This rule acknowledges that people may not always have a current ID, but their identity can still be reliably established. For instance, if a signer presents a driver's license that expired last year, it is perfectly acceptable for the notarization. The key is the "issued within 5 years" rule, not whether it is currently valid. Question 25. An acknowledgement certificate attached to a document is missing the venue. What should the notary do? A. Cross out the entire certificate and attach a new one. B. Fill in the correct state and county in the venue section before signing and sealing. C. Proceed with the notarization, as the venue is optional. D. Return the document to the signer to have the creator add the venue. Answer: B. Fill in the correct state and county in the venue section before signing and sealing. The notary is responsible for ensuring the notarial certificate is complete, and this includes filling in the venue, which indicates where the notarization took place. If the venue, State of California, County of ___________ is blank, the notary must write in the county where they are physically performing the notarial act. It is not the signer's or creator's responsibility to complete the certificate, it is the notary's official duty. Always remember to complete the venue yourself before you sign and stamp the certificate.